Can you avoid probate without a trust? My name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to answer that question for you. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can follow along on my social media. I'm at Amanda Rocha Law. You can comment on any of those videos or even send me a direct message. So, why are we talking about avoiding probate without a trust? I thought, Amanda, you always say we need a trust. Well, not everybody needs a trust. It depends on the assets that you have. So I'm going to give you a few tools that people use in order to avoid probate when a trust either isn't needed or wanted. With a caveat, if you don't want a trust but you need a trust, there really isn't much you can do to avoid probate in certain situations. So we'll kind of get into that. First things first, there are certain assets that will always avoid probate with or without a trust, as long as those assets are properly created. So first of all, if you have a joint bank account or any kind of, it could be money market, it could be checking, savings, it doesn't really matter. If it's a joint account that you hold with one or more people, when you pass away, those other people on the account are immediately going to take your portion and it'll be split evenly amongst them. There is no reason for that to go through probate. They are now the owners. The exception would be if you have a payable on death account and you've made sure that your funds are separate than the other person. It's very hard to do that, and in a joint account, nearly impossible, so you need to have extensive contracts signed. So for most people, if you have a joint bank account with a spouse, let's say, and the spouse passes away, the money in that account is going to immediately go to the surviving spouse without being counted towards probate. Other assets that always avoid probate if done correctly include beneficiary accounts, 401ks, life insurance, IRAs, that kind of thing. As long as the beneficiary is listed and the beneficiary is not your estate, it is a person who is able to receive over the age of 18, has the ability to be found by the company who holds your account, and isn't incarcerated or something like that that would make them not able to receive the funds, then that account will also avoid probate. Most people are concerned about their homes and their personal property, and that is where you see the most estate planning taking place around for the everyday common people. When you own property in California, if it's not a modular or mobile home, it will most likely trigger probate when the last owner dies. The reason I say most likely is because there are very few properties that do not meet the probate threshold of $184,500 currently in 2023, and those very few properties will be able to go through a small estate procedure. For anything else, if you jointly own property with a spouse, or if it's joint tenancy with a right of survivorship, the surviving person is supposed to receive your portion when you pass away. Sometimes documents aren't properly recorded or created, and you might think it's one way, but it's another. So when you have a house or real property in California, a trust is really the best vehicle in order to not only avoid probate, but make sure that your portion goes to who you want it to go to. Otherwise, it may go unintentionally to who else is on the title or their heirs instead of your heirs if it's tenants in common, that kind of thing. Or not tenants in common, I should say. If it's tenants in common, your portion will go to your heirs. If it's joint tenancy, it'll go to the last person to pass away's heirs if they don't have an estate plan. So then what about personal property? How do we handle things like vehicles and art and jewelry? Well, probate is only going to be necessary if the estate totals up to $184,500, the fair market value of all of your items on the date of your death. If you have a vehicle and some personal property, including bank accounts that are not joint accounts or payable on death accounts, art, jewelry, and it doesn't add up to that amount, then there's small estate procedures that avoid probate. But what you can do with vehicles is there's a form with the California DMV that allows you to select who will receive it on death. It's kind of like a beneficiary form. It's called transfer on death. And you can fill that out and submit it to the DMV so that when you pass away, your heirs do not have to wait 40 days in order to prove that a probate isn't necessary for your items to be collected. This way, the vehicle can be passed immediately upon your death as long as they have proof with your death certificate that it goes to whoever you've listed. As far as other personal property goes, you can have a will. The will isn't necessarily going to be going through a full probate if your assets don't reach the total. And other ways that you can make sure other people get things is joint ownership, making sure that they know what you have. If it's something like stock certificates, you can fill out documents with the company to make sure that your items go where they need to go. If you have questions about anything specific or anything I spoke about, please comment down below if this platform allows you to do that. You can go on my website, www.amandarocalaw.com. There you can schedule a strategy session with me and we can talk about this or anything else, estate planning and probate related. Or you can follow along on social media and send me a message. I'm at Amanda Rocha Law. Thank you.